as we believe that this case can be decided on summary disposition at this time. And thank you for the opportunity to argue this motion. Here in Ohio, we don't always argue these orally, and I appreciate the opportunity to be here for this. So this case arises from a pool contract. I'm not sure how much the court has sunk its teeth into the motion briefing of this yet, but basic story is that Bella Blue Pools was contracted to perform a pool installation at Danny Cheney, the plaintiff's home. At some point during the first several months, Danny Cheney canceled it and didn't want it done anymore. And then now she's asking for a deposit back. A preliminary issue in this is that there's no question there's a written contract. It's in the pleadings that admitted between the parties that the contract governs the transaction. This written contract was attached to the, I think, complaint, and the defendants admitted that. To simplify the motion for the court, Danny Cheney is claiming that Bella Blue Pools breached the contract, but Danny Cheney has not identified any particular term of the contract that was breached. The only allegation, granted, there's a lot of facts and kind of a play-by-play that the plaintiff alleges, but when you really drill down to the root of the issue of what is actually the breach of the contract, the only argument they are claiming is that Bella Blue Pools did not install or start the pool installation fast enough. In other words, in a timely manner. But there's no contract term defining what the schedule is for the pool installation. And certainly I'm sure the court is somewhat aware there's going to be, typically, if there's a deadline, the contract is going to say time is of the essence. Or they might actually specify a deadline by which the pool has to be installed. There was no deadline, and there's no time is of the essence clause in this contract. That's really important because if they're claiming that Bella Blue Pools breached timeliness, they have to have some substance in the contract that says that. So you take a look at that, and you also take a look at what we put in our reply brief, which was a quote from Danny Cheney during her deposition, where she acknowledged an email she sent to Bella Blue Pools that said that she understood the season is hectic and that the timeline was initially discussed but not fully finalized earlier in the year. And that makes sense. When we're dealing with construction contracts, one thing that can be anticipated is the unanticipated. Circumstances happen like weather, labor shortages, supply chain issues, especially right now within the last couple of years. It is virtually assured that there's going to be some hiccups in how quickly a pool or a construction agreement can be delivered to a customer. And that's what happened here. Bella Blue Pools was targeting installing it in late July, but it didn't happen. Instead, they were available to install it the week of August 17th, which is really not that much longer. It's about 2 weeks past the target date that they had. Danny Cheney then wanted to cancel the contract and has not allowed Bella Blue Pools the opportunity to install it since. Bella Pools has been ready, willing, and able to do so, but they haven't been able to. And that's where we kind of reach into the flip of the breach of the contract claim. Because Danny Cheney barred them from being able to perform on the contract and did so for a reason not within what's allowed under the contract, she herself has breached the contract by preventing the performance of this contract. She made a deposit of $25,000 for the pool. That has not been returned at this time. Bella Blue Pools, I think to this day, has been willing to try to install the pool, but has not been allowed on their property since. Bella Blue Pools has made a counterclaim for breach because they haven't been able to fully execute the contract to perform. So they have a claim for lost profits on the job. That, of course, is a fact issue, and we're not claiming a certain amount of damages or anything right now, but there is the basis to find a breach of contract claim, to find Cheney's breach of contract claim without basis, and to find that she has, in fact, breached the contract herself. To quickly clean up two other issues, the plaintiff also, as complaints typically have, they have more than one cause of action. They also file a cause of action for unjust enrichment. I'm assuming in the alternative to finding that a written contract exists, the parties agree there's a written contract, so the unjust enrichment claim should not persist. And similarly, they also made a claim for fraud. It appears even from the pleadings, the fraud claim is based on the same allegations as the contract claim. I don't believe the plaintiff is proceeding with the fraud claim at this point, but I'll let Ms. Berger speak to that more directly. But I would also say in the briefs, we set forth why the fraud claim is without merit as well. With that, Judge, I hope you have an opportunity to read all the briefs, our moving brief, her opposition, our reply, and all the attachments. We're confident we'll find that this can be decided by, or at least partially decided by a dispositive motion.
All right, very good. Thank you so much. Ms. Berger?
Thank you. Quickly, Mr. Ward, did you file a reply to our brief?
Yes.
I did not get that. So if you could send me that, that would be great.
Absolutely. Yes. Okay. I apologize for that.
Yeah,
Becky,
no
could you see if we have scanned in or the clerk's office has a reply brief? It could be across the hall, but I don't have it either. So it might just be across the hall still. So we'll look for that. Okay, Ms. Berger.
Yes, thank you, Your Honor. As Mr. Ward stated, I represent Danny Cheney, the plaintiff in this action. Defendant's motion is based on MCR 2.116C10, basically asking that the court find that there is no genuine issue of material fact, and that it is impossible for the plaintiff to support her claims because of some deficiency in the record. We propose that there are several genuine issues of material fact. The basic one being that defendant is claiming my client breached the contract, and my client is claiming that defendant breached the contract. Our allegation is that plaintiff failed to perform. There has not been a pool installed on this property, and since December of 2022, there was no contact at all between the parties. So it's not like they were still reaching out asking to schedule a date. There was literally no contact at all for several years. So there is a bit of a timeline, I guess in this case, Your Honor, that I would like to run through briefly and point out some issues that we have and some things that I think are genuine issues of material fact, things such as modifications in writing and agreements or offers and acceptance by my client that have not been taken into consideration. So this case started in March of 2022. Like Mr. Ward stated, there was a tentative installation date of July of 2022. And the defendant stated that he already had the pool shell on hand. So it was going to be able to be a quick install because he already had it in one of his warehouses. On the 29th of that month, my client was informed that the plot plan that they currently had needed to be submitted to get a proper permit, and the defendant stated that they wouldn't be able to move forward without it. So they scheduled an appointment in April. They scheduled it for April 26th. April 25th, the defendant canceled the appointment and rescheduled it for the 27th. The 27th, the defendant canceled the appointment again, less than a half an hour before the scheduled appointment. It was rescheduled for May 4th, 2022. Defendant canceled the appointment again, this time at 12:13 for a 1:30 appointment. And then late June of 2022, plaintiff was assured by the defendant that the pool installation was on schedule still for the mid or end of July of 2022, and that he would personally contact her a few days before installation would start. In, it looks like July of 2022, defendant was still failing and refusing to communicate with the plaintiff. Plaintiff called and emailed defendant several times. Again, there was no response. So there were several months there where he was supposed to have been coming to install, where she took off work, where she was available, that there was no communication at all from the defendant. The defendant didn't show up. They didn't make contact. They didn't attempt to install the pool in any way. In August of 2022, the defendant finally reached out to plaintiff and wanted to install the pool the very next day, so August 16th. That request was not reasonable. My client could not accommodate it. He couldn't get off of work. She had family obligations. And that's when she sent the email that Mr. Ward identified. And that email stated, "No work shall be done on my property until verbal and written contact is made with me for any type of formal agreements or amendments to be made." This was not a blanket refusal to perform, but a request for communication that again went unanswered. So on the 18th, the defendant emailed plaintiff and stated that they will be amending the contract the next day. That again never happened. On August 22nd, the defendant emailed plaintiff and offered them 3 options to be able to move forward. Option 1 was to continue with the current contract. Option 2 was to pay the difference between the deposit and what the shell costs and have the shell be delivered. Or option 3 was to refund her deposit minus the cost of expenses so far. Plaintiff elected to accept option 3 and requested a refund in the amount of $24,700. I think there was a $300 permit that the defendant had already gotten. On the 25th, plaintiff, my client, phoned the defendant, received no return communication until October, almost 2 months later. In October, the defendant again requested communication. Emailed defendant again requesting communication and was advised to call the owner. So she phoned him on the 18th of October, did not hear back. Phoned him again on the 19th of October, did not hear back. And then on November 2nd, the parties had a meeting and the defendant gave the plaintiff 3 revised options. 1, continue with the current contract. 2, outright buy the shell at the value, pay for shipping from the manufacturer, which was confusing to plaintiff because defendant stated that he already had the shell on hand. Or 3, the defendant could partially install the pool and plaintiff would be responsible for piping, electrical, and concrete work. Plaintiff agreed to think about those options. And then in November of 2022, plaintiff finally received an email from defendant and responded on December 4th, asking more questions, but never refused to allow the installation of the pool. And then in December 19th was the last communication between the parties, and where defendant emailed stating that he would get back to plaintiff after the new year in 2023. Plaintiff never heard back and was forced to start this action. So there are a lot of facts. There's a lot of timeline, I guess, issues, but it's plaintiff's position that when when looking at this motion in the light most favorable to my client, there's no way that the court can find there exists no genuine issue as to any material fact. Nor can the court find that it's impossible for the plaintiff to support her claims because of the facts stated in our brief and on the record. So we are asking that plaintiff's motion be denied and that this issue be permitted to proceed within the court's discretion. Thank you.
Okay, Mr. Ward.
Yeah, a brief reply is in order. So this kind of goes back to what the court has to do. Obviously, every contract has lots of facts, a wide net of things that may conceivably be relevant to a claim for breach of contract. So what we all have to do is cut to the heart of the issue. What is the actual breach that's claimed? It's not whether a phone call is not returned. And granted, we fully believe that this list of emails and phone calls is highly selective. For example, we have emails which were submitted that state that Bella Blue Pools reached out to Danny Cheney in October, on October 25th, October 31st, November 1st, November 13th. They made attempts to try and reach her on a number of occasions, which they're selectively leaving out. But irrespective of that, it doesn't really matter. What matters is, what is the breach that Cheney is claiming that Bella Blue's committed? That's really the simple issue at heart here. And the only claim they have is that Bella Blue Pools did not install this pool in a timely manner. So you have a contract that was made in March with an expectation, admittedly, by Cheney that was hoping for a target date in July of when it was going to be installed. Granted, it went behind schedule, and they offered to install it in August, and she said no, and she said no more work should be done on my property until I basically authorize you to do so. And she has never authorized them to go back and finish the pool. And you'll see in some of the emails that they offered to go back and finish this project. With regard to, going back to what the basic facts here are, is whether or not there's a breach of contract. There isn't one. They offered to build the pool and install it within a reasonable amount of time, which is the issue here. No contract term was breached, so the only question is, was it timely within a reasonable amount of time in the industry? Cheney does not have any expert witnesses or other people to say that Bella Blue Pools offered to install the pool in August of the same year that the contract was signed was in any way an automatic breach of the contract. The other stuff notwithstanding. With regard to the question of whether or not this contract was modified or amended because there was some sort of settlement agreement, that is not the complaint in this case. There has been no allegation in the complaint that there was an offer and acceptance of a settlement agreement, which I think they're trying to claim now. That is a completely separate issue. And with regard to whether or not they offered a couple of options, every single case, especially civil cases before the court, are going to have some attempts by the parties to resolve the matter. But then it's incumbent upon, if somebody's trying to claim that this is a motion to enforce a settlement agreement, they have to come forward with proof that that itself was an actual contract. And in this situation, they have one instance where Bella Blue Pools was trying to work it out with them. And Cheney, I guess they stated that Cheney accepted an option and demanded back $24,700, which Bella Blue Pools never actually agreed to that amount, which is a big problem. If you're going to try and claim that there's a settlement agreement, one of the material terms to the settlement agreement is agreeing to an amount. If there's no agreement on an amount, you don't have a contract for a settlement agreement. And with regard to attempts after that to try and reach a settlement agreement, it looks like that was never finalized either. So that kind of is a divergence from what is the root issue in this case, which is pled by the plaintiff in her complaint, which is the pool contract is the contract. And she's claiming a breach of that, which again, we don't have any proof of that. That's what I had to say in reply. Thank you.
Okay. All right, so I'm going to take this under advisement and we will issue an opinion in a timely manner. We are set for trial in February of next year. So yeah, so it should be out fairly quickly. So thank you.